Start. The appellants were youngsters aged 20 and 19 years when they fell foul of the law. Stop. On 14 to 2003, at around 7:30 p.m., the appellants, along with co-accused Gurpreet Singh, approached the complainant PW1 to hire a taxi to go to a village stop en route, when at their behest the car was stopped, Gurpreet Singh caught hold of the complainant and the appellant. He faced trial before a juvenile court. Stop. Jagdeep Singh took a dagger and inflicted 6-7 injuries on PW1's forehead. Stop. Appellant Lakhveer Singh inflicted 2-3 injuries on his abdomen and 1 injury on his neck using a knife. Stop. The complainant was thrown out of his taxi and the 3 people fled with the taxi. Stop. In pursuance to the reporting of the crime by complainant, an FIR was registered on 15 to 2003 under section 382 and section 307 read with section 34 IPC. Stop. Knife and dagger were recovered along with the taxi, and the trial court framed charges under section 397 IPC. Stop. Post trial, the appellants were convicted by the trial court wide judgment dated 8/1/2005 and sentenced to undergo rigorous imprisonment of 7 years each. Stop. The appeal preferred by the appellants has been dismissed by the impugned judgment dated 24/10/2019. Stop. The appellants approached this court by a special leave petition. Stop. Annexed thereto, the compromise deed arrived at between the complainant Amrik Singh and the appellants before us, in terms whereof the complainant has stated that he did not want to pursue any action against the appellants and has no objection to their release on bail or acquittal. Stop. The appellants have already served about 50 years of their sentence while in custody. Stop. On 3/12/2020, this court, while recording the aforesaid plea, issued notice on the SLP and on the prayer for interim relief of bail while simultaneously impleading the complainant is the second respondent. Stop. On 18/12/2020, counsel for the state and respondent number 2 entered appearance and counsel for respondent number 2 confirmed that the dispute had been amicably resolved. Stop. However, counsel for state number 1 submitted that the minimum sentence provided by the statute under section 397 is 7 years and the same cannot be reduced below that period. Stop. On his submission, learned counsel for the appellants sought benefit under the Probation of Offenders Act, 1958, hereinafter referred to as the Act. Stop. It is on the limited conspectus of the aforesaid aspect that on 11/1/2021, we granted leave and reserved the judgment upon conclusion of arguments and the parties having filed their respective synopses. Stop. Over.